Oh, good evening for the live crew. Good whatever for you replay crew members. Thanks for being here. We are, man, you know where we are? Well, I am in Western Pennsylvania where it is snowy and cold. One of the best times of the year for me. I love the winter weather. It's beautiful right now. Reminds me of something. Winter weather reminds me of something. I remember. It's the death of John O'Keefe. And that's what we're talking about today. It's really easy to lose the victim in the whole circus that surrounds Karen Read and her trial. It's really easy to lose the victim. It's kind of like OJ. We forgot that there were two people that were murdered, right? And that's the way the Karen Read trial kind of feels to me. We forget that we are talking about a man who lost his life, an off-duty officer who did die, and there are multiple theories out there as to what happened. But I mean, I guess that's the crux of things, right? And we all know that Officer O'Keefe died January 29th of 2022. Is that right? That is right. I want to make sure that I've got somebody check me on that. Anyway, he died in the cold of Boston, right? Boston area. Now, obviously, the prosecution, who was originally led by this guy, a guy named Adam Lally, he has been replaced by Special Prosecutor Hank Brennan. They alleged that it was Ms. Read who who ran over Mr. O'Keefe with her SUV. She argues through her attorneys, Alan Jackson, David Yannetti, that she wasn't even there. She wasn't even close to there. And the thing that is the thing that they're all arguing about right now is a potential dog bite. Okay. So let's not bury the lead. I want to start talking about this woman. Her name is Dr. Marie Russell. Okay. Now, in the first trial, as I understand it, and hey, guys, I'm going to have Sean McDonough on here pretty soon. He is one of the best guests I've ever had. Sean is going to come back. He couldn't join me tonight, but he's going to come back real soon, and we're going to be talking about the twists and turns of this case. But so he'll know way deeper everything. He knows way more than I'll ever know about this case. So on a surface level, what happened is once the trial had already begun, the defense brought in a expert witness, and we can learn about this in a story that was published on Boston.com back in June. Okay, so we're going to go back to June. Let me bring you guys over here. Where am I going? Going here. No, that is not right. I'm going here. This is a story from June, and what happened is the defense brought in Dr. Russell as an expert witness, and the prosecution objected, saying no. And they did, outside the presence of the jury, what is called a voir dire. Or sometimes you hear voir dire or voir dire. Whatever it is, it's Latin. It's voir dire, right? Voir dire. Which basically is, we're going to question you, and it's basically your direct voice. We're going to listen to your direct voice to determine if you are a good expert witness or not. Let me bring this up just a little bit more. Oop, wrong way. Oh, it doesn't want to go anymore. Okay. Is that right? Yeah, okay. Okay, so defense expert Dr. Marie Russell, a retired emergency physician and forensic pathologist, said she has a high degree of medical certainty that the abrasions on John O'Keefe's arm were the result of animal bites or scratches. And remember, this is voir dire from June. Okay. We're not talking about the current case. This is the first trial. Prosecutors and defense attorneys clashed over whether Russell should be permitted to testify in Karen Read's trial, as the prosecution only received notice of Russell's expected testimony in late May. Judge Beverly Canone, this is her, who she presided over the trial, has not yet determined whether Russell will be allowed to take the stand. She ultimately did. During Tuesday's voir dire, Russell explained she had first heard of Read's case in mid-May after coming across an article from the Boston Globe. She said she connected with Read's team through someone at the Los Angeles County District Attorney's Office, where defense attorney Alan Jackson once worked as a prosecutor. Questioned without the jury present, Russell described her early career as a police officer in Malden and her training in hit-and-run collisions. She said she later worked on cases involving animal attacks at the Los Angeles County Coroner's Office and authored and co-authored several peer-reviewed articles on law enforcement dog bites. After reviewing documents from Read's case, including hospital records, autopsy photos and reports, and the medical examiner's grand jury testimony, Russell said she formed some opinions about the injuries on O'Keefe's right arm. They're consistent with a large dog attack, Russell opined. And remember, I talked with Sean about this in the first time he was a guest here. We talked about this. My layperson opinion, they look like dog bites. Yeah, they do to me. But what do I know? I'm just like a YouTuber sitting in his office in an old house in Western Pennsylvania. What do I know, right? Okay, so after reviewing we did that. Jackson displayed photos of O'Keefe's wounded arm. I have kind of pixelated out some of this, but this is one of those photos, okay? So Jackson displayed photos of O'Keefe's wounded arm, and Russell pointed to marks she believed were caused by animal teeth or claws. She further explained that she ruled out a car crash as the cause very quickly, as O'Keefe's major injuries were limited to his head. Responding to a later question from ADA Adam Lally, Russell confirmed her training in hit-and-run crashes was relatively rudimentary, as Lally put it. She also confirmed she is board certified in emergency medicine, but not in any form of pathology. Now, these are lawyerly, I don't want to call them tricks because that's prejudicial. And you guys know that I really love good lawyering on both sides of a case. I love good lawyering. So I don't want to call it a trick, but lawyers have very specific training on how to establish or impeach is the word that they use, a person's expertise. And remember, expert witnesses are different than regular witnesses. Expert witnesses can share their opinions on things. They can be there during the testimony of other witnesses. They can share their opinions, okay? So they're very good at impeaching, and if somebody is not board certified in forensic pathology, that does not exclude them from working as a forensic pathologist. If they have the training, but they're not board certified, sure, there are coroner's offices and medical examiner's office that would hire those doctors. But he seems to have made it seem like she has no bona fides in that one, especially in the hit and run crashes, right? Yeah, there would be doctors that specialize in hit and run crashes. They would be a very small population of medical doctors and DOs, right? That would be a very small group of people. He apparently is the one who called it relatively rudimentary, but she worked in an emergency room. So she certainly knew more than him about it. Anyway, Cannoni pointed to records indicating Russell received documents concerning the bite history of a dog named Chloe, a German Shepherd mix owned by the Albert family, who also owned the home where O'Keefe's body was found. According to the judge, Russell also received DNA test results from the University of California, Davis Veterinary Genetics Laboratory Forensic Unit, which found no signs of canine DNA on swabs taken from O'Keefe's shirt. Russell said she didn't recall seeing the documents in question. In his quest to bar Russell, again, in the first trial, they wanted to exclude Dr. Russell as an expert witness, and that is the reason for the voir dire, right? Okay, so in his quest to bar Russell from testifying, Lally cited both the late disclosure and Russell's decision to approach the defense several weeks into the trial. Cannoni and Jackson had a tense exchange over whether Jackson misrepresented how Russell came forward to offer her expertise. Quote, "There's not that many doctors who have published in the area of dog bites specifically," Jackson noted, adding, "I understand that it was well into the trial, but that's not a fault of ours." Lally suggested that if Russell were allowed to testify, her testimony should be limited to her opinions on what caused the injuries to O'Keefe's right arm, which... Anyway, so that sets the stage, okay? Now, what is happening in the case? Well, the first trial ended in a mistrial, and they have decided to go ahead and retry Karen Read in court for the murder of Officer O'Keefe. And they're now going through the same processes that they would go through, that they went through in the first trial. And lo and behold, Mr. Brennan does not want Dr. Russell to testify. Shocking, right? Because it pokes holes in the prosecution's story, which is the defense's job. So what we have to take a look at that for you guys is this document right here, which is their motion that they filed the day before yesterday. It's Commonwealth's motion to exclude the testimony of Dr. Marie Russell and a request for a Daubert Lanigan hearing. I have to remember what a Daubert Lanigan hearing is. Hang on. Daubert Lanigan hearing. Daubert Lanigan hearing is a court proceeding where a judge evaluates whether an expert witness's testimony is reliable enough to be presented to a jury based on the standards set by the Daubert case. Okay, got it. All right. So he basically is like, let's hold a hearing and see if we can exclude this witness. All right, so this is a short motion, and then we're going to get into your comments. In fact, I wonder if we should get into your comments before we read this motion. Hang on just one second. Let's bring up a couple of your messages and let's take a look, okay? First off, I did notice PJ's been a member for 3 months. He's been a fanatic for 3 months, PJ. Welcome. And yes, ultimately we want justice for John O'Keefe. Thank you very much for saying that. Okay. Hankey's non-existent integrity says, Gavin, I'm in Central PA. I've been hoping you were going to do another show on the case. I'm a huge Free Karen Read Justice for Officer John O'Keefe supporter. Date was 1/29/22. Thank you very much for that. I appreciate that, Hankey. Glad that Lula is here. Thank you, Lula. Jen, you may want to reconsider Sean's expertise. Listen, Jen, like I recognize that Sean is solidly on one side of this. I totally get it. But he does have investigative expertise, and he's a person that I like. And I am totally cool with people that don't like him or disagree with him. And I mean, when I had Sean on, I followed that up with someone on the other side. I had Jen Coffindaffer on, which, oh my goodness, I got so much crap for that from the people that are on the Free Karen Read side, right? So I totally get it, but we're going to talk to people. We're definitely going to be talking to people that are elbows deep in the case, so to speak. Let's see. PJ says, Gavin, can the judge continue to block evidence that is favorable to Karen Read or exculpatory? Okay, so here is the thing that we have to remember, okay? A judge's job is to rule on the law, not on necessarily the evidence. Like specifically, it's not, or I mean, they will, but the main purpose of the judge is to make sure that the fidelity of the law remains intact, right? That is his or her specific job. Now, how do they judge whether they're a good judge or not? Like personally, and I've shared this before. I went to it was a portrait hanging ceremony for a retired chief judge of my county's Court of Common Pleas, which is basically the equivalent of what is happening in Karen Read's trial, right? It's the first level. It's where trials happen. And in his, that was basically a retirement party kind of for him. I know he already had one, but it was celebrating him. He gave a speech. He gave a terrific speech, in my opinion. And he talked about how defense attorneys and prosecutors liked working with him, but they did not like how long it took for him to sometimes rule on an objection or on a motion in his court, because he took it very seriously, and he was very proud that at the end of his many decades sitting on the bench, there was never a successful appeal on a decision that he made. All right. So that is what judges in this level of court judge themselves on. Are they overturned on appeal? And if they are a lot, they consider themselves not so good, or maybe their peers might think that they're not so good. So back to PJ's question, can the judge continue to block evidence that is favorable to Karen Read or exculpatory? My answer to that is yes, if she thinks that the law requires it. And it's open to her interpretation. And I mean, that is the reason for the appellate process, because judges make mistakes all the time, right? So yes. Man, that was a lot of talking just to be able to say to PJ, yes. Yeah, just a heads up, there is a bit of controversy, around Sean. Yeah, I've been aware of it. Thank you very much. Let's see. Let me just scroll down. Polo's mama says, Gavin, I'm not a fan of Karen Read. However, I do not think this is hit and run. My father, when he was about 60, was hit by a car at 35 miles an hour. He stood up, dusted himself up, vehicle was dented. Yeah, I was hit on a motorized bicycle. I used to have a Whizzer, if you guys know what those are. If you don't, look them up. They're amazing. But it was my commuter bike for a while. I had a 12-mile commute, and if I took the surface streets, I could avoid traffic. And then I learned that if I had just a motorized bicycle, man, I could save money on gas and stuff like that. So that's what I did. Anyway, I was hit on my Whizzer. It hurt. It was at a greater speed than 35 miles an hour, and I walked away. So, yeah, Polo's mama, it does seem a little far-fetched to me that the whole theory that he was hit. But I'm prepared to be wrong. I'm completely prepared to be wrong on that. Just Chrissy the Crone says, Gavin, how do you feel about there being no confidential aspect regarding press? Chrissy, I think I'm gonna have to interpret what your question is because it's not really clear to me. You might be talking about how open the courtrooms are and how there are cameras allowed in there and the ability to get documents in the case and photos and stuff like that. Is that what you're talking about? If that's what you're talking about, I honestly am all for it. If that's not what you're talking about, let me know because I'd love to. I'd really love to answer the question that you wanted answered. I love transparency in the legal system. I love it. And I am disappointed in the Commonwealth of Pennsylvania, where I live, that the transparency is so bad. We have an opaque system, as far as I'm concerned, here in Pennsylvania. Man, it is so hard as a reporter, which is what my day job is. My day job is. It is so hard. The bureaucracy is thick, and the red tape is like made of carbon fiber. It is so hard to get stuff. So I'm all for it. Now, it does make it a little more difficult to get a jury, but remember, we all kind of live in a true crime bubble where this is in front of us all the time. People who live outside the bubble, the Madeline Soto case is a very good example of it. There have been people that have commented here on the channel about how they live in the Kissimmee, Florida area, and they talk to people all the time that have no idea about the case. So we kind of live in this true crime bubble where we are hyper vigilant, hyper focused. And so we think that maybe it's going to affect the fairness of the trial. And I just don't think so. I think that they'll be able to find a fair jury. I hope that was your question, but let me know if it wasn't. Peppermint Gavin, she's probably talking about the Boston Magazine reporter having to release notes. Dateline in 2020 releasing outtakes, etc. There are no shields. Oh, yeah. Is that what she asked? Let me go back up. No confidential aspect regarding press. Oh, I see what you're saying. There's no law in Massachusetts that protects the press. Man, I've got my hair is so long right now, guys. I don't like that. I don't like that at all. I'll have to look into that. That is news to me. Is there are a lot of us where that's a hill we'll die on. We won't give up our sources. We won't, let out things that are confidential. But, interesting. Okay, got it. So they want the work product. I see. No, I don't like that at all. I don't like that at all. Jen Willis says, Gavin, yes, that is what judges are supposed to do, which is also why they recuse themselves when there's a conflict of interest. That is true. But remember, what we might interpret as a conflict of interest, a judge may say that is not a conflict of interest. I'm trying to think of a good example of this. Well, for example, okay, so I live in a small county. Okay, it's a big county, but small as far as the number of residents that live in the county. And in our county, you're hard pressed to find somebody that you either don't know or you don't know somebody who knows them. I've only lived here 7.5 years and I'm already at that point. I know everybody. So that means that all of the judges, all of the magistrates, all of the sheriffs, well, there's only one sheriff, but the deputies, all of everybody who works in the court system, we all know each other. So say a person that is a neighbor of a judge gets accused of a DUI and he's brought before the judge. We might say there's a clear conflict of interest here. You know that person. But according to the law, the judge may say, no, I can judge here. I can do it. So I mean, but what is the, I guess, what is the indication to us ultimately whether there was a conflict of interest or not? It is in the appellate process. And it sucks. It takes a long time, but it's designed that way. I don't know. I hope I answered those questions pretty well. Oh, there's one more that I'm going to do before we get into this. Kelly says, Gavin, please ask Sean why he thinks there's so much animosity toward him. I would love to hear his response. Yeah, my guess is that Sean doesn't care if people like him or not. It's that kind of personality that you need to be in law enforcement anyway. He probably doesn't even think a thing of it, but I'll ask him. When he comes on, I will ask him. Okay, let's come on back over here and talk about what we are here to talk about. Okay, the Commonwealth respectfully moves this honorable court to exclude the defendant's proposed expert testimony of Dr. Marie Russell because, one, the defendant failed to prove that the testimony meets the requirements as set forth in Daubert v. Merrill, blah, blah, blah. Okay, and Commonwealth v. Lanigan. So one is a U.S. law, one is a Massachusetts or U.S. precedent, one is a Massachusetts precedent. 2, the defendant failed to prove that Dr. Russell is a qualified expert in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behaviors. And 3, the testimony cannot be reliably applied to the facts. Okay, so on May 21st, 2024, the defendant provided the Commonwealth with the curriculum vitae. By the way, I looked for Dr. Russell's CV. And I don't think that it's included as an exhibit in the document that I got. It's not. I looked for the CV. A curriculum vitae is basically just a very fancy word for a very long resume. So I couldn't find that, but I did find that the closest I could get was this website, which is an expert witness directory, where she basically says that her general specialties are emergency medicine and forensic pathology. She has an MD from the University of Massachusetts. She's been in practice for over 35 years. She is board certified in emergency medicine. She has forensic pathology experience, correctional healthcare experience, and autopsy review, 29 years of physician experience at a level 1 trauma center, retired faculty member at USC Keck School of Medicine. She taught physicians and medical students for over 20 years. She's a former California Medical Board in-house medical consultant. She's the CDCR Chief Medical Executive, retired, certified correctional healthcare professional, former full-time police officers for 7 years, fellow of the National Association of Medical Examiners, fellow of the American Academy of Forensic Science. She has over 500 autopsies performed. Okay, so I would hardly say she is not an expert, but they're saying she's not an expert in these specific things. Okay, so they got the CV of Dr. Russell, May 21, and a proposed expert witness not previously disclosed. Defense counsel reported to the court that they first engaged with Dr. Russell on May 17, 2024. See the voir dire, Exhibit 2. On May 30th, 2024, during the 6th week of the defendant's first trial, and after the Commonwealth had called over 50 witnesses, the Commonwealth received the following limited synopsis about Dr. Russell. However, the Commonwealth never received any written reports or opinions. So it says, she has reviewed the autopsy photos, grand jury testimony of Dr. Scorti-Bello, the entirety of the autopsy report, all reports associated with Chloe's prior bite history, photographs of the items in evidence, and the UC Davis DNA testing results and evidence submission forms. She is expected to be called with focused testimony related to the right arm injuries. Again, the right arm injuries sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack, namely teeth or claw marks, or a combination of both from an animal. She will also testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. She will base her opinions and conclusions in part on having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. On June 6th, 2024, the Commonwealth moved to exclude Dr. Russell. This is the report that we just read, right? Due to the defendant's failure to comply with, Massachusetts Revised Criminal Procedure 14, probably is what that means, and renewed its request for reciprocal discovery by seeking court-ordered production of the required expert proffers, opinion evidence, and all expert reports. And indeed, Judge Cannoni did rule that the defense was in violation of the reciprocal discovery rules. Anyway, on June 18th, the court ruled that the defendant violated that law for the failure to comply with reciprocal and expert discovery. The only remedy to the Commonwealth was an opportunity to conduct a voir dire examination of the defendant's experts, including Dr. Russell, 2 months into trial on June 18th. Following the voir dire hearing, the court permitted Dr. Russell to testify and render an opinion that the abrasions on the victim's arm, quote, were inflicted by either teeth or claw marks and consistent with a large dog. The Commonwealth moves that this court reconsider its finding that Dr. Russell was qualified to render an opinion in the defendant's first trial, and that the methodology or theory underlying her opinion, particularly without any corroborating evidence, was reliable. An expert witness is not permitted to testify to matters beyond an area of expertise or competence. And then it has case law that we're supposed to look at. The Commonwealth asserts that Dr. Russell is not qualified to render an opinion about the victim's injuries, nor is her opinion reliable, and respectfully requests a Daubert-Lanigan hearing to assess whether the defendant may call Dr. Russell in her second trial. The role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience. It is the defendant's burden to establish that Dr. Russell's testimony will assist the trier of fact to understand the evidence or to determine a fact in issue, and that the methodology or theory underlining the expert testimony is sufficiently reliable to be presented for the jury's consideration. The crucial issue in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. Now, this is a place where I don't like this. Well, it's not that I don't like it. It's just that there is an idea that you must have some sort of training, some sort of education, formal training, some kind of formal education, some sequence of letters behind your name, some sort of whatever that indicates that you are an expert witness on a particular thing. However, I disagree with that, because if a doctor is working in the ER for 20 plus years and he or she is presented with multiple dog bites over the course of all that time, and in fact, she has written papers on the subject that are peer reviewed, I don't think that education and training have anything to do with that. I think experience and familiarity definitely does, but it does seem like they didn't say or here. They said education, training, experience, and familiarity. Like all four things must exist. And I just don't think that I don't think it's cool. Hopefully, Dr. Russell will be allowed to testify. Although Dr. Russell is a trained emergency room physician, the defendant has failed to prove that Dr. Russell has a reliable basis in the knowledge and experience of her discipline to render an opinion in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behavior. Yeah, well, you don't need to be a veterinarian to know what a dog bite is. You can be a doctor. You don't need to have dental experience, like canine dental experience. And forensic odontology, that is a very, very specific thing. Very specific. So, and it doesn't matter. I don't even think forensic odontology even applies here. I really don't. But anyway, most of Dr. Russell's canine experience was from 28 years ago and focused on law enforcement canines in a 1996 article, Managing Law Enforcement Canine Dog Bites in the Emergency Department. During her trial testimony, Dr. Russell conceded that there was no law enforcement canine involved, and in her experience, a bite and hold injury that law enforcement canines are trained to do would appear different than a domestic canine and arguably vastly different from the victim's minor abrasions, which were isolated to one area of the forearm. Hang on. I mean, I don't know that I would call those minor abrasions. I would call them abrasions. So I don't like the prejudicial language in this in this argument, in this motion. Okay, while Dr. Russell may be able to provide expertise on how one would treat or provide wound care, she lacks sufficient expertise in identifying characteristics of a canine bite, predominantly from an autopsy photograph. Dr. Russell also has no training in forensic animal odontology. I mean, who has that? Come on. Nor any training or expertise in animal behaviors or domestic animal attacks. I mean, again, 2 decades in an emergency room. Okay. With only anecdotal experience and no corroborating evidence, Dr. Russell should not be permitted to testify that the injury depicted was specifically caused by a large dog consistent with teeth or claw marks, and that there were puncture marks, little round marks, inflicted by the actual point of a tooth. Again, there were a couple here that I thought were punctures, like, well, you guys can't see but like right near his elbow, the forearm near the elbow, those look like puncture wounds to me. Okay. Now I get it. I should back up here for a second. I totally get it that you've got to make your argument, right? And he's making a compelling argument to the judge. I just think that he's using prejudicial language that isn't really fair. But I mean, it's his job to make a solid argument. Okay. A jury should not be permitted to consider such speculative evidence, and Daubert-Lanigan requires that this court determine whether the expert's conclusions have a reliable factual basis and are limited only to matters within Dr. Russell's precise field of expertise. Again, everybody has fields of expertise beyond what their formal education is. I mean, come on. Okay. A proposed expert's opinion should be disregarded where it amounts to no more than mere speculation or a guess from subordinate facts that do not give adequate support to the conclusion reached. The knowledge of a proposed expert must indicate more than subjective belief or unsupported speculation. Furthermore, Dr. Russell's opinion is in dispute with forensic findings that there was no canine DNA associated with the swabs taken from the area of the victim's clothing near the abrasions. Dr. Russell had failed to review the UC Davis Veterinary Genetics DNA report prior to rendering her opinion and testifying at the voir dire hearing. By the way, you guys know I'm from Northern California. UC Davis is in my stomping grounds, my neck of the woods. And with all the chill in the air and the snow on the ground, I would not mind being back in Northern California right now. But I don't have to wait long. Later this month, we'll be back. Okay. Dr. Russell testified that she did review the DNA report indicating there was no canine DNA present. However, her opinion did not change. This court need not and should not admit unreliable opinion testimony based only upon the expert's unsupported assertions and desire to render an opinion that resolves an unsubstantiated and defense-driven controversy. And you know what? The no canine DNA is an issue for sure. In addition to whether Dr. Russell is qualified, this court must also determine that the expert's testimony is sufficiently reliable to reach the jury. As the proponent of the evidence, the defendant must prove by preponderance of the evidence that Dr. Russell's methods and processes behind her opinion, despite a lack of any corroborating evidence, are scientifically reliable. In Lanigan, the Supreme Judicial Court adopted a portion of the Supreme Court's ruling in Daubert and held that general acceptance in the relevant scientific community will continue to be the significant and often the only issue, but that a proponent of scientific opinion evidence may demonstrate the reliability or validity of the underlying scientific theory or process by some other means. The proponent of the evidence may establish reliability by demonstrating general acceptance of the methodology in the relevant scientific community or by applying a non-exclusive list of Daubert factors, including whether the scientific theory or process has general acceptance in the relevant scientific community, has been or can be subjected to testing, has been subjected to peer review and publication, has an unacceptably high known or potential rate of error, and is governed by recognized standards. Okay, blah, blah, blah. Basically, yeah. Okay. Dr. Russell claimed no scientific or technical basis for her opinion and offered little more than anecdotal experience and vague generalizations. During trial testimony, this court sustained several objections during Dr. Russell's direct examination as Dr. Russell attempted to set forth her opinion, and she lacked any reliable methodology or explanation for assessing how it could be opined that the abrasion was from a canine versus a different animal or versus a blunt force object. How could she assess the size of the supposed canine and what her methodology was to opine there were puncture marks from the points of a tooth, but also quite possibly a claw? No methodology was even alluded to within her testimony at any point. This court must limit its analysis to reliability of the methodology suggested, not the perceived persuasiveness of a proposed expert's conclusions, particularly one that Dr. Russell is not qualified to make, which is not supported by evidence nor scientific reliability, and was born 6 weeks into trial. So for the foregoing reasons, the Commonwealth respectfully requests that the defendant satisfy her burden of establishing Dr. Russell's proposed testimony meets the requirements set forth in Daubert v. Merrill Dow Farms and Commonwealth v. Lanigan, and that the testimony of Dr. Russell be excluded at the defendant's upcoming trial. And there they are. Hank Brennan. Where's Mr. Brennan? Mr. Lally. And then I did not prepare Miss McLaughlin's picture. Should have done that. All right, guys. Let's bring up John here. He's our victim. We got to remember. Got a victim here, man. Okay, let's see what you guys are saying over here. Goodness. Let's see. Gavin, tell us a bit more what you saw. You said didn't sit well with you and why. I think you asked this question 15 minutes ago. I think I covered it pretty well. If the prosecution were confident in this case, would they attempt to block Dr. Russell's testimony? Yeah. I mean, it is their job as prosecutors to do the best they can to get the case presented that proves beyond a reasonable doubt that the defendant did what they alleged that she did. They should be, what is the word that I'm looking for here. They should be diligent in their efforts to do everything they can to win. And of course, it should be at the ultimate goal of getting justice, right? They shouldn't just try to win for the sake of winning. But I don't think that this is an indication that they're not confident in their case. PJ, thank you very much for gifting those memberships. Gigi says justice for Chloe. Poor Chloe's dragged through the mud. Amy says, Gavin, do you think she will get off again? It's really hard to say what juries will do. It is so hard to say what juries will do. I want to give you a couple examples, and I've given you these before, but like last year, my goodness, guys, oh, this is going to drive me nuts. I'm definitely going to get a haircut. I want to grow my hair long, but this is killing me. Okay. Last year, I reported on trial. I sat through the whole thing, gavel to gavel, from jury selection all the way to the verdict. And then I went back for his sentencing, the whole thing. There was, in my opinion, I had heard everything that the jury had heard in that trial. And this was a trial where the defendant alleged self-defense, that he thought that he was in danger for his own life, and therefore he killed the victim. And I personally thought that the defense did a very good job, a persuasive job, of presenting to the jury that yes, indeed, he reasonably believed that he was in danger of his life. And in fact, there was a moment where the Dr. Eric Vey, who has since retired, he was the forensic pathologist that handles kind of all of Northwest Pennsylvania. He worked out of Erie, but he handled 17 counties. It was huge. It was done with a long gun. He testified to like the length of the barrel and where the barrel would have been when the gun was fired. And I thought that it completely supported the defense's testimony. And I felt that the prosecutor misrepresented Dr. Vey's testimony in his closing statement. I think that he was like, I think that he was just blatantly misleading the jury. I really do. Anyway, the jury goes back to deliberate, and I'm like, this is going to be fast because he obviously did this in self-defense. I mean, I'm sorry that there was a victim, but he obviously did this in self-defense. They came back and they convicted him. And like, I got to stop saying like so much, but I had decided I'm just going to go grab lunch real quick. I'm going to walk up the street. I'm going to grab a sandwich. It's not that far away. I had walked up the street, ordered my sandwich, sat down, and had taken one bite when I was told that the jury had reached the verdict, come back to court now. Like, it was crazy. Gotta stop saying like. Okay, so that's one example. Number two, this just happened. This was, I mean, I still have my notebook from the trial. When did this happen? I'm trying to... goodness sakes. There we go. Okay, so what I don't know why I care so much about this. This was mid-October. The trial started October 14th, okay? All right. In this trial, a man who had been diagnosed with schizophrenia for 20 years had what appeared to be a schizophrenic episode. He, in the middle of the night, walks from his rural home and ends up completely naked on the front porch of the victim. And then when the victims realizes there's a naked man on the front porch, we should open the door and see if he's okay. They open the door, that turns into a scuffle, and it ends up that the defendant disarmed the victim of his revolver and shot him dead. Okay. So I thought that the defense put on a very good defense, including expert witnesses, establishing this guy is suffering from schizophrenia, and he was experiencing a schizophrenic break. And for weeks afterwards in the Clarion County jail, he had to, like, he wouldn't put on clothes. Like, it was crazy. And the jury had a couple of different options. One was guilty by legal insanity, not guilty, or not guilty because of legal insanity. Either way, it didn't matter what happened. The defendant was going to be going to some sort of facility, right? I thought the defense did a very good job. The prosecution did a very good job too. The defense did a very good job, and the jury came back that day. I think they deliberated for 2 hours as guilty, just straight up guilty. And I couldn't believe it. So, and I felt bad about it because this guy who obviously needs to be locked up for the rest of his life, but it needs to be in a hospital, right? So anyway, those are two examples of, you never know what a jury is going to do. You just never know. And I'm sorry to keep harping on this, but you guys know that I served on a jury for a double homicide years ago. Kimberly and I were in our first home. So it was probably within the first, let's see, I think it had been just over a year since we'd been married. We've now been married 25. Where I sat through that trial. I was juror number 2, and I listened to all the testimony, all of the witnesses, the expert testimony, the arguments, the whole shebang. And I said to myself, oh, it's so terrific that this is so cut and dry, that we can just go into the jury room and deliberate for a few minutes, and then we'll be done. And I could not believe that I was in the minority of people that held my opinion. My opinion from the beginning was 2 counts of first-degree murder. And we ended up convicting him of 1 count of second degree, 1 count of first degree. So you just never know. We had a woman in that jury that she had all of her notes, but it was like she didn't hear anything. We're looking at our notes, all of us, our notes all jive. Yours don't, but she dug in her heels. So it's very difficult. Very, very difficult to say. Great question. I believe Mr. Jackson is still defending Karen Read. I believe that is the case. Somebody correct me if I'm wrong, but I think it is. Let me scroll down. Hanky says, Gavin, watch Garrett Wing. He's a dog bite expert and actually trains dogs to bite. You'll have 0 questions about John Arms after watching the video. I will look it up. Thanks, Hanky. In fact, somebody else told me to do that, and I hadn't done it before. I need to do that. Thank you. What just happened? It refreshed again. Hate it when it does that. Okay, a couple more. They should be diligent to find the truth. Yeah, well, that is part of the ethics of being a prosecutor. If they don't believe that they're right, they should not be prosecuting the case. So they should be diligently seeking justice for sure, seeking truth for sure. Yeah, I agree with that. Now, it's an imperfect system, so I'm sure that there are prosecutors that don't seek diligently the truth and actual justice. I'm sure that is the case. So I take your comment. Thank you. Speaking of losing thought of the victim, Karen and Aiden have surely forgotten that this isn't about them and that they aren't the victims, in my opinion, only. Yeah, of course, you're talking about Karen Read and Aiden Kearney, also known as Turtle Boy. I have decided just not to consume his content. I went to his website, the Turtle Boy Media website. This was months and months ago, and it was just so full of prejudicial language that I didn't believe him. So he may be wrong, he may be right. I don't care. I can't consume his material because it's just so prejudicial. You should be able to, even if you believe one side of a thing, of a story, of um, a case, or of whatever, a phenomenon, whatever. If you only believe that one side, you should be able to have a devil's advocate view of it as well in everything. Like if you are in a disagreement with your spouse, you should be able to say, well, she says she sees it this way. What would that mean if I saw it that way? You should be able to do that. Or a parent or a friend or whomever, you should be able to do that on the little things, on the big things. And I just don't think that that the content that I consumed reflected that he was able to do that. So, Kat, that's a great comment. Kat says if those were dog bites, they would be on the underside of the arm also. Let's see. Hopefully the neighbors will do the right thing and give up the front yard surveillance of Brian and Nicole's house because it exists. Yeah, there's just a lot in this case, man. There's just so much in this case. Gavin, the obvious animal scratches, sneaky cops replacing floors, Mr. Albert, a cop not coming outside to see if his dead friend on his lawn, dog rehomed, Karen Read is not guilty. Yeah, I think that, there are beliefs on both sides. And the crappy thing about this is that, like, say, again, talking about being able to do devil's advocates here, right? Say Karen Read is guilty. Say that she is guilty. Or just imagine that is in the realm of possibility. The fact that the police behaved in the way they did, it muddies the waters, and it makes the it makes it so that if she were guilty, justice for John O'Keefe is very, very difficult to get. And if she's not guilty, then it's just full on corruption, right? So either way, the behavior of the police was just so bad here that I think that there will be doubts on both sides of this one for a long, long time. All right, guys, I think you guys have some great comments here, but I think that's where I'm going to leave it. Quick little reminder that you can head on over to the fish tank. Let me bring up my web browser. If you go to my website, which is gavinfish.com, and you click on this little fishy up here in the corner, a little kind of inconspicuous little white fishy up there, that will take you over to the fish tank, which is our Facebook group. It's run by Jamie, who's also one of our awesome moderators. She's having a couple issues, some medical issues, and so we don't see her as much in the mod, but she really takes care of us over on the fish tank. We like to talk about true crime. We like to talk about cases. Please join us over there. Reach out to me anytime by clicking on that little icon. That'll bring up a little form that you can use to contact me. Also, when you look at the cases on my website, they are full of just all sorts of stuff. Let's take Veronica Butler and Jillian Kelly's case, for example. So many documents in there, and the way that you can get unfettered access to my documents is through my Patreon. So, you can click on the little Patreon logo here, and you can support me that way if that is your thing. We will be back tomorrow, 7:30 p.m. Why did I do that? 7:30 p.m. We will be back tomorrow. And as always, so that will be that'll be our last live stream of the week. Won't be back on Saturday, Sunday. I want to give you guys a heads up that during the Christmas holiday, I'm going to be out of town. I'm going to be spending that time with my family, so we won't be doing live streams pretty much after the 22nd or 23rd. I'll be back in Northern California visiting the folks and my nieces and nephews and brother and sisters and in-laws, the whole shebang. So want to give you guys a heads up on that the end of the year will kind of feel like nothing is going on. What is really going on is I will be enjoying some family time. Okay, with that, guys, I'm going to bid you adieu. Thank you very much for being here. I will see you on the next one. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.